Good afternoon, everyone.
Hey, I was waiting for us to go live, so we're back.
So before we bring our jury in, I just would like to make an announcement. The court is going to be moving into the jury instructions, otherwise known as the jury charge. We do ask for minimal interruptions, so please note the court would request your patience with the charge if you intend to stay. And I would also request your cooperation in not entering and exiting the courtroom unless you absolutely have to. With that, I will instruct the marshals that if someone needs to leave, obviously let them leave. And it is an open courtroom, so if someone wishes to come in, please allow them to come in. The only thing that I would like to avoid is repeated interruptions. Okay, so thank you for that. The next thing that I would like to do is just address counsel relative to the remainder of the proceedings. So after I provide the jury their charge, I'll exclude the jury very briefly. I'll hear any exceptions or comments relative to the charge. I'll also be instructing you at that time to please get together with the clerk. There are many exhibits in this case. Please check the exhibits. I want to make sure that you stipulate on the record that all full exhibits are going in for deliberations and that any exhibits that have not been marked as a full exhibit are not going in to the jury for deliberations. Another thing that I'd like to do before we get that started is I did provide to each one of you a copy of the jury evidence laptop's external DVD guide, which was provided by IT. The jury will be provided with a laptop. It is a clean laptop. It will have the capability to listen to the audio exhibits as well as any DVD video exhibits, and this will provide instructions to the jury. Does anyone have any objection to the court providing that to the jury?
No objection.
Okay. All right. Is there anything further that anyone would like to address?
Nothing from the defense, Your Honor.
All right. So I did go ahead and do two things to the charge generally. I did add the verbiage from the amended information into the specific offenses, and I also did add the Roman numeral 1 and Roman numeral 2 just to identify the counts within these particular charges. Additionally, where we had lesser offenses or lesser included offenses, I did add the word to murder, okay, of murder, so that there was no confusion. I thought that that would provide the best direction to the jurors in trying to move along through these instructions. They are pretty lengthy. All right. Does anyone have any concerns regarding the proposed charge at this point?
Have a mistake, Your Honor.
Okay. With that, I would ask the clerk to please bring our jury in.
Hey, y'all. Thank you so much for being here. It's good to see you. Good to see you. So this is going to be jury instructions, and then they're going to deliberate, and we'll be on verdict watch. Hey, punk banjo.
Welcome back.
I don't think it'll take
Counsel,
long,
please
honestly.
stipulate to the return of our jurors.
Stipulate.
Thank you. All right, members of the jury, you have heard the evidence presented in this case. I am now going to instruct you as to the law that you are to apply in this case. During these instructions, I will, for the most part, be reading from prepared material. I do this so that I do not inadvertently give you an incorrect instruction. So if I lose eye contact with you from time to time, please bear with me. The reading of these instructions is going to take some time. I'm not sure if I'm going to break or if we're going to try to get through the instructions in all one sitting, okay? So first I'm going to talk to you about the function of the court and the jury. It is exclusively the function of the court to state the rules of law that govern the case with instructions as to how you are to apply them. It is your obligation to accept the law as I stated. What I tell you, not what the attorneys tell you, is the law that you are to follow. If the law, as I give it to you, differs in any way from the claims of law made by counsel, dismiss from your minds what counsel have said to the extent it differs from what I tell you. You must follow all my instructions and not single out some and ignore others. They are equally important. Also to note, in these instructions, the court does use the terms information and amended information, first count and count 1, second count and count 2, and crimes and offenses interchangeably. You as jurors are the sole judges of the facts. It is your duty to find the facts. You are entitled, in the course of evaluating the evidence, to draw any and all inferences you will find reasonable and logical from the evidence you hear. You are to recollect and weigh the evidence and form your own conclusions as to what the ultimate facts are. You may not go outside the evidence introduced in court to find the facts. This means that you may not resort to guesswork, conjecture, or suspicion, and you must not be influenced by any personal likes or dislikes, opinions, prejudices, or sympathies. You should not be influenced by my actions during the trial in ruling on motions or objections by counsel, or in comments to counsel, or in questions to witnesses, or in setting forth the law in these instructions. You are not to take my actions as any indication of my opinion as to how you should determine the issues of fact. If I asked any questions of a witness, you must not assume that I hold any opinion on the matter to which my question may relate. Remember that you, as jurors, are at liberty to disregard all comments or questions of the court and the witness's responses to those questions in arriving at your own findings as to the facts. You must not take anything I said or did during the trial as indicating what I think of the evidence or what your verdict should be. Any reference I may make to the evidence is only for the purpose of clarification of some point of law or a point of illustration, or to refresh your recollection as to the general nature of the testimony. I do not intend to emphasize any evidence that I mention or limit your consideration to it. If I do not mention certain evidence, you will use the evidence from your recollection. If my recollection of the evidence does not comport with your recollection, then it is your recollection which must prevail because you are the exclusive trier of the facts. The defendant justly relies upon you to consider carefully his claims, to consider carefully all the evidence, and to find him not guilty if the facts and the law require such a verdict. The defendant rightfully expects fair and just treatment at your hands. At the same time, the state of Connecticut and its people look to you to render a verdict of guilty if the facts and law require such a verdict. The law prohibits the state's attorney or defense counsel from giving personal opinions as to whether the defendant is guilty or not guilty. During my instructions to you, I may repeat certain instructions. I apologize in advance. I do this for the purpose of organization. You are not to consider a repeated instruction more important than any other instruction. All instructions are equally important. Also, in the course of my instructions to you, I may refer you to a previous instruction given. When I do this, I will identify it for you and direct you to the section to which I am referring. Presumption of innocence. In this case, as in all criminal prosecutions, the defendant is presumed to be innocent unless and until proven guilty beyond a reasonable doubt. This presumption of innocence was with this defendant when he was first presented for trial in this case. It continues with him throughout this trial unless and until such time as all evidence produced here in the orderly conduct of the case, considered in the light of these instructions of law and deliberated upon by you in the jury room, satisfies you beyond a reasonable doubt that he is guilty. The presumption of innocence as to each crime charge and as to any lesser included offense as instructed by the court may be overcome only after the state introduces evidence that establishes the defendant's guilt beyond a reasonable doubt. If and when the presumption of innocence has been overcome by evidence proving beyond a reasonable doubt that the accused is guilty of a crime charged or any applicable lesser included offense as instructed by the court, then it is the sworn duty of the jury to enforce the law and to render a guilty verdict. Burden of proof. The state has the burden of proving that the defendant is guilty of the crimes with which he is charged or any lesser included offense as instructed by the court. The defendant does not have to prove his innocence. This means that the state must prove beyond a reasonable doubt each and every element necessary to constitute a crime charge or lesser included offense as instructed. Whether the burden of proof resting upon the state is sustained depends not on the number of witnesses nor on the quantity of the testimony, but on the nature and quality of the testimony. Please bear in mind that one witness's testimony is sufficient to convict if it establishes all the elements of a crime beyond a reasonable doubt. What is reasonable doubt? The meaning of reasonable doubt can be arrived at by emphasizing the word reasonable. It is not a surmise, a guess, or a mere conjecture. It is not a doubt raised by anyone simply for the sake of raising a doubt. It is such a doubt as in serious affairs that concern you, you would heed. That is, such a doubt as would cause reasonable men and women to hesitate to act upon it in matters of importance. It is not hesitation springing from any feelings of pity or sympathy for the accused or any other person who might be affected by your decision. It is, in other words, a real doubt, an honest doubt, a doubt that has its foundation in the evidence or a lack of evidence. It is doubt that is honestly entertained and is reasonable in light of the evidence after a fair comparison and careful examination of the entire evidence. Proof beyond a reasonable doubt does not mean proof beyond all doubt. The law does not require absolute certainty on the part of the jury before it returns a verdict of guilty. The law requires that after hearing all the evidence, if there is something in the evidence or lack of evidence that leaves in your minds as reasonable men and women a reasonable doubt as to the guilt of the accused, then the accused must be given the benefit of that doubt and acquitted. Proof beyond a reasonable doubt is proof that precludes every reasonable hypothesis except guilt and is inconsistent with any other rational conclusion. Evidence. The evidence from which you are to decide what the facts are consists of 1, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. 2, the exhibits that have been received into evidence as full exhibits, including pictures, videos, or documents that have been marked as full exhibits. 3, any facts that the court judicially noticed. And 4, any stipulations of the parties. In reaching your verdict, you should consider all the testimony and full exhibits admitted into evidence. Certain things are not evidence, and you may not consider them in deciding what the facts are. These include 1, arguments, statements, and questions by lawyers. The lawyers are not witnesses. What they have said in their closing arguments is intended to help you interpret the evidence, but it is not evidence. If the facts as you remember them differ from the way the lawyers have stated them, your memory of them controls. It is not proper for the attorneys to express their opinions on the ultimate issues in this case or to appeal to your emotions. Also, attorneys have a duty to object when they believe a question is improper under the rules of evidence. You should not be influenced by the objection or by the court's ruling on it, and you are not to hold it against any party for making objections. During the course of trial, you may have heard counsel stand up and make comments about questions made by opposing counsel. You are not to regard any comments that counsel may have made in your deliberations. Any comments about the propriety of questions are not proper for trial or your consideration and should not be used in your deliberations. Lastly, the question the lawyers ask of witnesses are not evidence. It is the testimony of the witnesses in response to the attorney's questions that is evidence. Also not evidence include number 2, testimony that has been excluded or stricken. If I have excluded certain testimony, you must follow my instruction to disregard the testimony. In effect, I'm telling you to do what may be difficult, but which you will have to do to best accomplish, and that is to accept in your minds that such stricken testimony is not evidence and must not be considered in your deliberations. Also, some testimony has been admitted for a limited purpose. Whenever I have given a limiting instruction, you must follow it. 3, Anything you may have seen or heard when the court was not in session. 4, anything you may have seen or heard from any spectators during the trial. And 5, the document called the amended information, which you will have with you at the time of your deliberations. The information is merely the formal manner of accusing a person of a crime to bring that person to trial. You must not consider the amended information as any evidence of the guilt of the defendant or draw any inference of guilt because he has been charged with crimes. You will note that each count in the amended information contains within it the alleged time, date, and location of the offense. The state does not have to prove the exact time, date, or location of the offense beyond a reasonable doubt. However, the state must prove each element of each offense, including identification of the defendant, beyond a reasonable doubt. Additionally, evidence has been admitted in this case concerning Vanessa Morales and the investigation efforts concerning the location of Vanessa Morales. It is important that you understand that Jose Morales is not on trial for any crime concerning Vanessa Morales, and your deliberations and your verdict as to each count in the amended information is limited to the crimes charged by the state. You are not to concern yourselves with the whereabouts of Vanessa Morales or allow sympathy to play a part in your deliberations as to the 2 counts in the amended information: murder of Christine Holloway and tampering with physical evidence. The court will provide additional instructions concerning those specific offenses charged by the state further along in this jury charge. I'm going to talk to you about direct and circumstantial evidence. There are generally 2 kinds of evidence, direct and circumstantial. Direct evidence is testimony by a witness about what that witness personally saw or heard or did. Circumstantial evidence is indirect evidence. That is, evidence from which you could find that another fact exists, even though it has not been proven directly. There is no legal distinction between direct and circumstantial evidence as far as probative value. The law permits you to give equal weight to both, but it is for you to decide how much weight to give any particular evidence. Circumstantial evidence of an event is the testimony of witnesses as to the existence of certain facts or evidence or the happening of other events from which you may logically conclude that the event in question did happen. By way of example, let us assume that it is a December night and you're preparing to retire for the evening. You look out the window and see that it is snowing. You wake up the next morning, come to court, and testify that the night before it was snowing in the area of your house. That is direct evidence of the fact that it snowed the night before. You saw it, and you came into court and testified to that fact. Now assume that it is another December night, the weather is clear, there is no snow on the ground, and you retire for the evening. You wake up the next morning, you look out the window, and you see snow on the ground and footprints across your lawn. You come into court and you testify to those facts. The evidence that the night before there was no snow on the ground and the next morning there was snow on the ground and footprints across your lawn is direct evidence. That direct evidence, however, is circumstantial evidence of the fact that sometime during the night it snowed and that sometime thereafter someone walked across your lawn. The only practical difference between direct and circumstantial evidence is that when you have direct evidence of some fact, the main thing you have to do is determine the believability of the direct testimony given, the credibility of the witness. With circumstantial evidence, you must first determine the credibility of the witness or witnesses and decide whether the facts testified to did exist. Then, you must decide whether the happenings of those events or the existence of those facts leads logically to the conclusion that other events occurred or other facts exist, and ultimately, whether the crimes alleged were committed by the accused. There is no reason to be prejudiced against evidence simply because it is circumstantial evidence. You make decisions based on circumstantial evidence in the everyday affairs of life. There is no reason why decisions based on circumstantial evidence should not be made in the courtroom. In fact, proof of circumstantial evidence may be as conclusive as would be the testimony of witnesses speaking on the basis of their own observation. Circumstantial evidence, therefore, is offered to prove a certain fact from which you are asked to infer the existence of another fact or set of facts. Before you decide that a fact has been proved by circumstantial evidence, you must consider all of the evidence in light of reason, experience, and common sense. Redacted exhibits. There are some exhibits that have been accepted into evidence as redacted versions of the original. These redactions were made by way of agreement by counsel or by order of the court, and you must not speculate as to why the information was redacted or what was redacted. Redacted information is not evidence, and as indicated earlier, you may not go outside the evidence introduced in court to find the facts. This means that you may not resort to guesswork, conjecture, or speculation. Credibility. In deciding what the facts are, you must consider all the evidence. In doing this, you must decide which testimony to believe and which testimony not to believe. You may believe all, none, or any part of any witness's testimony. In making that decision, you may consider a number of factors, including the following. 1, was the witness able to see or hear or know the things about which the witness testified? 2, how well was the witness able to recall and describe those things? 3, what was the witness's manner while testifying? 4, did the witness have an interest in the outcome of this case or any bias or prejudice concerning any party or any matter involved in the case? 5, how reasonable was the witness's testimony considered in light of all the evidence in the case? And 6, was the witness's testimony contradicted by what that witness has said or done at another time, or by the testimony of other witnesses, or by other evidence? If you think that a witness has deliberately testified falsely in some respect, you should carefully consider whether you should rely upon any of that witness's testimony. In deciding whether to believe a witness, keep in mind that people sometimes forget things. You need to consider, therefore, whether a contradiction is an innocent lapse of memory or an intentional falsehood. And that may depend on whether the contradiction has to do with an important fact or with only a small detail. These are some of the factors you may consider in deciding whether to believe testimony. The weight of the evidence presented does not depend on the number of witnesses. It is the quality of the evidence, not the quantity of the evidence, that you must consider. The evidence that Jose Morales was previously convicted of a felony and a misdemeanor larceny is only admissible on the question of the credibility of Jose Morales as a witness, that is, the weight that you will give his testimony. Such evidence is not admissible to prove the guilt of Jose Morales in this case. His criminal record bears only on his credibility. It is your duty to determine whether Jose Morales' testimony is to be believed wholly or partly or not at all. You may consider Jose Morales' prior convictions in weighing his credibility and give such weight to those facts that you decide is fair and reasonable in determining the credibility of Jose Morales. Evidence has been presented that Jose Morales made a statement to the Ansonia police outside of court that is inconsistent with his trial testimony. You should consider this evidence only as it relates to the credibility of his testimony, not as substantive evidence. In other words, consider such evidence as you would any other evidence of inconsistent conduct in determining the weight to be given to the testimony of the witness in court. The law treats an omission in a prior statement as an inconsistent statement. Testimony of police officials. Police officials have testified in this case. You must determine the credibility of police officials in the same way and by the same standards as you would evaluate the testimony of any other witness. The testimony of a police official is entitled to no special or exclusive weight merely because it comes from a police official. You should recall the police official's demeanor on the stand and manner of testifying, and weigh and balance it just as carefully as you would the testimony of any other witness. You should neither believe nor disbelieve the testimony of a police official just because he or she is a police official. I'm going to talk to you about expert testimony. In this case, certain witnesses have taken the stand, given their qualifications, and testified as expert witnesses. A person is qualified to testify as an expert if he or she has special knowledge, skill, experience, training, or education sufficient to qualify him or her as an expert on the subject to which the testimony relates. An expert is permitted not only to testify to facts that he or she personally observed, but also to state an opinion about certain circumstances. This is allowed because an expert from experience, research, and study generally has a particular knowledge of the subject of the inquiry and is more capable than a layperson of drawing conclusions from facts and basing an opinion upon them. An expert witness may state an opinion in response to a hypothetical question. A hypothetical question is one in which the witness is asked to assume that certain facts are true and to give an opinion based on those assumptions. The value of the opinion given by an expert in response to a hypothetical question depends upon the relevance, validity, and completeness of the facts he or she was asked to assume. The weight that you give to the opinion of an expert will depend on whether you find that the facts assumed were proved and whether the facts relied on in reaching the opinion were complete or whether material facts were omitted or not considered. Like all other evidence, an expert's answer to a hypothetical question may be accepted or rejected in whole or in part according to your best judgment. In this case, you were provided expert testimony by the following witnesses: Dr. Eric Fraser, Dr. Kristen Hartnick-McCann, Dr. Michael Hayes, Kristen Medell, Jennifer Nelson, Michael Morganti, and David Carney. Allowing someone to give expert testimony is in no way an endorsement by the court of the testimony or the credentials of the witness. Such testimony is presented to you to assist in your deliberations. No such testimony is binding upon you, and you may disregard the testimony either in whole or in part. It is for you to consider the testimony with the other circumstances in the case, and using your best judgment, determine whether you will give it any weight, and if so, what weight you will give to it. The testimony is entitled to such weight as you find the expert's qualifications in his or her field entitled it to receive, and it must be considered by you, but it is not controlling upon your judgment. You are also to consider his or her general credibility in accordance with the instruction on credibility applicable to all witnesses. Now, in this case, the defendant testified. An accused person, having testified, stands before you just like any other witness. He is entitled to the same considerations and must have his testimony tested and measured by you by the same factors and standards as you would judge the testimony of any other witness. You have no right to disregard the defendant's testimony or to disbelieve the defendant's testimony merely because he is accused of committing multiple crimes. Consider my earlier instructions on the general subject matter of credibility and apply them to the defendant's testimony. Going to instruct you now on proximate cause. Proximate cause does not necessarily mean the last act or cause or the act and point in time nearest to the death. The concept of proximate cause incorporates the principle that an accused may be charged with a criminal offense even though his acts were not the immediate cause of the death. An act or omission to act is a proximate cause of the death when it substantially and materially contributes in a natural and continuous sequence, unbroken by an efficient intervening cause to the death. It is a cause without which the death would not have occurred. It is a predominating cause, a substantial factor from which the death follows as a natural, direct, and immediate consequence. Intent. Intent relates to the condition of mind of the person who commits the act, his or her purpose in doing it. Specific intent. Specific intent is the intent to achieve a specific result. A person acts intentionally with respect to a result when his conscious objective is to cause such result. What the defendant intended is a question of fact for you to determine. In this trial, the concept of specific intent applies to the offense of murder at count 1 and tampering with physical evidence at count 2. Recklessness. A person acts recklessly with respect to a result or to a circumstance described by a statute defining an offense when the defendant is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. The risk must be of such nature and degree that disregarding it constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. The standard of conduct of a reasonable person in the same situation as the defendant is the doing of something that a reasonably prudent person would do under the circumstances, or omitting to do what a reasonably prudent person would not do under the circumstances. A gross deviation is a great or substantial deviation, not just a slight or moderate deviation. There must be a great or substantial difference between, on the one hand, the defendant's conduct in disregarding a substantial and unjustifiable risk, and on the other hand, what a reasonable person would have done under the circumstances. Whether a risk is substantial and unjustifiable is a question of fact for you to determine under all the circumstances. In this trial, the concept of recklessness applies to manslaughter in the first degree, subsection A3, as a lesser included offense, and manslaughter in the second degree as a lesser included offense at count 1. Evidence of intent. What a person's intention was is usually a matter to be determined by inference. No person can testify that he or she looked into another's mind and saw therein a certain knowledge or a certain purpose or intention to do harm to another. Because direct evidence of the defendant's state of mind is rarely available, intent is generally proved by circumstantial evidence. You will refer to my earlier instruction on direct and circumstantial evidence. The only way a jury can ordinarily determine what a person's intention was at any given time is by determining what the person's conduct was and what the circumstances were surrounding that conduct, and from that infer what his or her intention was. To draw such an inference is the proper function of a jury, provided, of course, that the inference drawn complies with the standards for inferences as explained in connection with my instruction on circumstantial evidence. The inference is not a necessary one. You are not required to infer a particular intent from the defendant's conduct or statements, but it is an inference that you may draw if you find it is reasonable and logical. I again remind you that the burden of proving intent beyond a reasonable doubt is on the state. Evidence of motive or the lack of it may also be considered by you in determining the issue of intent. You will refer to my instruction on motive below. Motive. The law does not require that the state in a criminal case prove a motive because it is not an element of the crime. It is not necessary for the state to prove what reason the defendant may have had for committing a crime charged. Because crimes are generally committed for some motive, evidence of a motive may tend to prove the guilt of a defendant. In the same manner, if there appears no adequate motive on the part of the defendant to commit the crime, that may tend to raise a reasonable doubt as to the guilt of the defendant. If the existence of a motive can be reasonably inferred, that may tend to prove the defendant's guilt. If no motive can be inferred, it may or may not raise a reasonable doubt as to the guilt of the defendant. If the absence of a motive does not raise a reasonable doubt that the defendant is guilty, then the fact that the state has not proved what the defendant's motive was does not prevent you from returning a verdict of guilty. Going to instruct you on intoxication. There has been some evidence to the effect that the defendant was under the influence of intoxicants, namely PCP and cannabis, at the time of the alleged acts. The statute pertaining to intoxication applies only to the offense of murder at count 1 and the offense of tampering with physical evidence at count 2, and reads in pertinent part as follows. Intoxication shall not be a defense to a criminal charge, but in any prosecution for an offense, evidence of intoxication of the defendant may be offered by the defendant whenever it is relevant to negate an element of the crime charged. Intoxication is defined by statute as a substantial disturbance of mental or physical capacities resulting from the introduction of substances into the body. If you find that the defendant was under the influence of an intoxicant at the time of the alleged acts, you must then determine what effect, if any, this voluntary intoxication had on his ability to form the specific intent required to commit the alleged crimes. Note that intoxication is not a defense to or an excuse for the commission of a crime. It is only relevant to negate an element of the crime charged, such as intent. If you find that the defendant was intoxicated at the time of the crime, you may take this fact into consideration in determining whether he was in such a state of intoxication as to be incapable of forming the required specific intent, which is a necessary element for the commission of the crimes of murder and tampering with physical evidence. If you believe that the defendant, although intoxicated, was still capable of forming a specific criminal intent, then the defendant's responsibility is the same as if he were not intoxicated. You must first decide whether the defendant was intoxicated at the time of the alleged crimes, and second, whether the defendant was incapable of forming an intent to commit the acts constituting the crime of murder at count 1 or the acts constituting the crime of tampering with physical evidence at count 2. Remember, the defendant does not have to prove that he was intoxicated. The state always has the burden of proving beyond a reasonable doubt that the defendant could form the required intent. Any degree of intoxication, not merely total intoxication, may be considered in determining whether the defendant possessed the requisite intent. Consciousness of guilt. In any criminal trial, it is permissible for the state to show that conduct or statements made by a defendant after the time of the alleged offense may have been influenced by the criminal act. That is, the conduct or statements show a consciousness of guilt. For example, flight, when unexplained, may indicate consciousness of guilt if the facts and circumstances support it. Such acts do not, however, raise a presumption of guilt. If you find the evidence proved and also find that the acts were influenced by the criminal act and not by any other reason, you may, but are not required to, infer from this evidence that the defendant was acting from a guilty conscience. The state claims that the following conduct is evidence of consciousness of guilt: the defendant's actions in cleaning up the scene of the crime, the defendant's actions in disposing of evidence from the scene of the crime, the defendant's flight from 6.5 Myrtle Avenue shortly after the welfare check by the Ansonia Police Department on December 2nd, 2019, and the defendant's statements to the police about not being present at 6.5 Myrtle Avenue the weekend of the incident. It is up to you as judges of the facts to decide whether the defendant's acts, if proved, reflect a consciousness of guilt and to consider such in your deliberations in conformity with these instructions. Identity of the defendant. The state has the burden to not only prove every element of a crime, but also the identity of the defendant as the perpetrator of the crime. You must be satisfied beyond a reasonable doubt of the identity of the defendant as the one who committed the crime, or you must find the defendant not guilty. If you have a reasonable doubt as to the accuracy of identification, you must find the defendant not guilty. Third-party culpability. There has been evidence that a third party, an unknown individual, not the defendant, committed the crime of murder of Christine Holloway, with which the defendant is charged. This evidence is not intended to prove the guilt of the third party, but is a part of the total evidence for you to consider. The burden remains on the state to prove each and every element of the offense beyond a reasonable doubt. It is up to you and to you alone to determine whether any of this evidence, if believed, tends to directly connect a third party to the crime with which the defendant is charged. If, after full and fair consideration and comparison of all the evidence, you have left in your minds a reasonable doubt indicating that the alleged third party, in this case an unknown individual, may be responsible for the crime the defendant is charged with, committing the murder of Christine Holloway, then it would be your duty to render a verdict of not guilty as to the accused, Jose Morales, at count 1. Specific charges brought by the state. I will now turn to the specific offenses charged in this case. The amended information in this case contains 2 counts against the defendant. In other words, the state charges the defendant with committing 2 separate offenses or crimes. You are to consider only the specific charges submitted to you and not concern yourself with how the information may have been read when it was read to you at the start of trial. Please note you will also be instructed to consider lesser included offenses under count 1 if applicable. Additional instructions on your consideration of lesser included offenses will be provided further along in this charge. The defendant is entitled to and must be given by you a separate and independent determination of whether he is guilty or not guilty as to each crime charged in each count, including lesser included offenses if applicable, in accordance with the instructions to follow. Each of the 2 counts charged in the amended information, including lesser included offenses at count 1 if applicable, set forth a separate and distinct crime. The state is required to prove each element of each crime charged in each count, including any lesser offenses instructed, to be deliberated upon at count 1 beyond a reasonable doubt. Each crime charged under each count, including any lesser included offenses where applicable, must be deliberated upon separately. Please note, the total number of counts charged in an information does not add to the strength of the state's case. You may find that some evidence applies to more than one count in the amended information or more than one crime under a count. The evidence, however, must be considered separately as to each element of each crime deliberated upon. Each count is a separate entity. You must consider each count separately, including lesser included offenses, if applicable, as instructed, and return a separate verdict for each count. This means that you may reach opposite verdicts on the two different counts. A decision on one count does not bind your decision on the other count. I have previously instructed you and herein reiterate that the amended information is not evidence. It is merely a paper statement of charges against the defendant upon which the state proceeds to trial. You must not consider it as any evidence of the guilt of the defendant or draw any inference of guilt of the defendant from the amended information.
Will the court consider a quick break?
Certainly. All right, so we are going to go into the specific charges next. So this is a good time to break. We're just a little over halfway done. So we're going to take a brief recess. Again, please don't discuss this case. I'm not done with my instructions and have not directed you to deliberate. So the court is going to stand in a 10-minute recess. Court will take a 10-minute recess.
This is the most annoying trial as far as trying to get through it. Like, we would have been done, and they probably would have been back with a verdict if they didn't break so daggone much. Like, good God almighty. Let's see what's going on with Lori. I got it pulled up on my phone so that as soon as they come back, we will know. Yeah, it's ridiculous. God. Let me write down this break. Do we not have any news channel? Let's see.
Is when we get back from lunch, but your staff can look at your team can look at the exhibits.
I'm going to back it up a little bit and see what's going on.
Injury to another person, or 2, using a deadly weapon or dangerous instrument. Conduct means an act or omission and its accompanying culpable mental state. Deadly weapon means anything designed for lethal use, including a firearm. Dangerous instrument means anything that is readily capable of causing death or serious physical injury under the circumstances in which it is used, attempted to be used, or...
I'm looking for the closing arguments.
If there is a second phase of this trial for aggravation, in addition to a dangerous...
Hey, Meemaw. There we go. Like, I'm assuming he's given jury instructions.
Or threat of physical force or
right
deadly
now.
Physical force only while the danger continues, and it ends when the danger ends. The force used may
Hold
not
on
be
just a
greater
minute.
than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical
These are
force or
definitely
deadly
jury
physical force is
instructions.
justified if
So
a reasonable person in the situation would have reasonably
where
believed
is
that
closing
immediate
arguments?
physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that, 1,
Go back to when the start of Law and Crime, Lori was a hot mess. Okay. Let's see. Let me pull it up on Law and Crime then. No, that's not what I want. Is this? Hold on. I thought it was saying specifically closing arguments. Lord of mercy. All right, you said go to the beginning.
Continued or attempted to use unlawful physical force against the defendant.
Oh, look, a squirrel.
Park
Okay,
Zoo,
cool.
yeah. Where Park West Auditorium used to be. Yeah.
Okay, Parks is so cool.
I always tell people we went to go see Dickie Betts from the Allman Brothers. Out comes this first group. Long hair. This is in the 70s, early 70s. Long hair, beads, everything. They didn't get through the first song. We threw stuff at them, got them off the stage.
Oh my gosh.
Well, next day we read in the paper it was the Cars.
Oh.
So, What's your name?
I'm Ashley.
Ashley, I'm Steve.
Nice
I used to work
meet
at,
you.
where are you from?
Hi, Ashley and
All right, I
Steve.
used to work at Channel 10 for 18 years.
Did
Serge,
Sergio
right?
tell you?
Huh?
Sergio's a good recruiter.
He didn't.
Okay. Oh, look, a
All
squirrel.
right, we're on the record. State of Arizona versus Lori Daybell, CR 2021-001-704. Why don't I have the state announce? And the defendant?
Lori Daybell?
All right, we met on Thursday and went over jury instructions. In the meantime, since Thursday, there was a few modifications sent out. We put drafts on your desk this morning.
They are.
Last week. Let me just pull up that email.
No eating in the court, please.
I don't know if they knew we could hear them.
Last week, the state requested some modifications that were made, and then on Friday, Advisory Council also requested a correction to the presumption of innocence, which I did do, as well as a mere presence instruction. Does anyone want to make a record on any of those changes that have occurred since we met Thursday? I forgot, I don't know if my staff told you, I did add, I realized standard number 9 was not added, which is defendant need not produce evidence, so I added that this morning as well. Have you had a chance to review the latest draft? Or do you need more time? We told the jurors to be here at 11, so we have time if you need more time.
Okay.
Other record you want to make on mere presence? All right, has the defendant had a chance to review the final instructions?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, we're still waiting for a few jurors to show up. The plan this morning Well, let me ask the defendant, you still plan on resting?
I do.
Okay, so when the jury comes in, I'll remind them that the state rested last Wednesday, and then I'll turn to you and you'll presumably say the defense rests. I'll read the jury instructions and we will break after I read the jury instructions.
Oh, wow.
Depending on what time we break, I'll tell them what time to come back for the closing arguments, approximately an hour later, or around 1 p.m.
That's cool.
While we're waiting, I had my staff email the parties about any potential aggravators. I didn't see a response to that. So in addition to, if there is a second phase of this trial for aggravation, in addition to a dangerous finding, does the state know what other aggravators it might be pursuing?
Emotional harm.
Anything else?
The presence of an accomplice.
Okay. And in the event that happens, would you be producing testimony or evidence, or would it just be argument?
Potentially testimony from Mexican.
Okay. All right. So how many jurors? You can go ahead and print out.
Your Honor, I have two issues I'd like to bring up real quick.
Go ahead.
The jury process of the jury alternate selection. Can you tell me what that process is going to be today?
It's literally drawing
It
two
sounds like
numbers out of randomly out of a container.
Okay. And when is that going to be done and how does that
Not
work?
till after the closing arguments.
Okay.
So the alternates are told that they're still alternates, they're not released, because I have had in the past jurors become sick or ill or not be able to deliberate, and we have to call back an alternate to deliberate. So they're still under the admonition until they're released.
So we're keeping all of them, basically.
But only 12 will go back and deliberate.
Okay.
If one of those 12 becomes sick or is unable to deliberate, we would bring in an alternate and release the person that can't deliberate. Does that make sense?
Yes.
All right, what else?
So it came to my attention this weekend that the exhibit number 286 that the state put into evidence that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes long.
Remind me, what's 286? Is whose interview?
It's my interview, I guess, with Detective Inkland.
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct?
Correct.
All right.
So is it just the snippets that were played all together?
It should just be the parts that were played in court. Is that correct?
Yes, I mean, they're all connected. But
All right.
the state redacted out the beginning, the end discussions of hiring. I would be hearsay or not.
Right. So did you have a question about that?
Yes. So is it just the snippets all put together, or is it the interview for the first 21 minutes?
I think it's just the snippets that were played in court that are put together as one exhibit.
There's connectors between all of it, but it does not include any of the beginning or the end of the interview.
Right, portions have been redacted out,
Yes,
but it's just more or less what was played in during testimony.
correct.
Does that answer your question?
Kind of, but Detective Inkland testified that it was the full interview. So what does that mean if she testified that it was the full interview?
Hey, Rubber.
I don't know. It's something you could have cross-examined her on, but now it's probably too late. If you wanted clarification on that, but the jury is going to know it's redacted, and they get the redacted exhibits instruction as part of the instructions. So either side can point that out to the jury that it's redacted. Anything else?
I was just assuming that that might have been an error to say that it was the full interview when it wasn't the full interview, and it was admitted into to reflect the record that it was the full interview. So are you telling me that the jury is not going to be able to go back and watch the full thing?
Your full interview?
Correct.
No, because it was never admitted into evidence.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the
Well,
exact
my advisory
testimony.
council checked the FTR and that's exactly what was said. That was exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was
So-
there sometimes they enter in the full interview for appeal purposes only, but that's not the one that actually gets shown to the jury. Was that the case?
Was not for appellate purposes.
Okay.
It is the full interview. The defendant talks to the detective in the beginning about Kylie, does not include that. She talks to the detective at the end about Kylie and victim services. It doesn't include any of that. She's sitting in a room for, I don't know how long while Kylie's being interviewed. It doesn't include any of that. It is her interview about what happened.
Okay. So the states closed their evidence.
I'm just trying to find out what the jury is going to be seeing. They have all that evidence in the evidence when they deliberate. Is that correct? They
Whatever
have
was,
access to that.
whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Okay, but from what I'm understanding from the state, just correct me if I'm wrong, it's not just the snippets that were played, but it's a partial part of the interview and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Ty Lee said or did or didn't happen, the hearsay parts were, the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness. Maybe it was the full interview of your version of what happened.
So we have
There.
our exhibit 20, the defense's proposed exhibit 20 is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No,
Why not?
your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full interview, either side could have clarified that with that witness. I don't know what that witness meant when they said that. Anything else?
That's it.
All right, we're getting the sufficient number of the jury instructions copied. As soon as that's done and our jurors get here, we'll read those instructions. All right.
We just came back into court for ours, so I'll go back to that. I was watching this and didn't see it, but it looks like they just sat down, so. Hey, heathen. Right. She is really insufferable. Inseparable. Tomorrow, Stefan should have a hearing on that continuance. Yep.
Counsel, please stipulate.
Yes, Your Honor.
I think, ladies and gentlemen of the jury, before I move on to the 2 counts of the information, I want to redirect your attention back to the instruction that I gave on third-party culpability. I inadvertently left out lesser included offensive, if applicable, in the last sentence of that particular charge. So in that subheading, which you will have a copy of these instructions, you will have the correct terminology, but I want to correct it on the record as well. So I'm going to reread that last sentence under third-party culpability. If after full and fair consideration and comparison of all the evidence, you have left in your minds a reasonable doubt indicating that the alleged third party, in this case an unknown individual, may be responsible for the crime the defendant is charged with committing, the murder of Christine Holloway, or any lesser included offenses, if applicable, then it would be your duty to render a verdict of not guilty as to the accused, Jose Morales, at count 1. Okay, so that included the correction. And now I'm going to bring you back to the specific offenses in this case. First count, murder, Connecticut General Statute, Section 53A-54A. The defendant is charged in the first count of the amended information with the murder of Christine Holloway in violation of Connecticut General Statutes, Section 53A-54A. The state charges in the first count that in the county of New Haven, in the city of Ansonia, on or about Sunday, December 1, 2019, between approximately 1:57 a.m. and approximately 6 a.m. at 6.5 Myrtle Avenue within said city, the said Jose Morales, with intent to cause the death of Christine Holloway, did strike Christine Holloway multiple times in the head and torso with an instrument that created several round-shaped marks that measured approximately 1 inch in diameter, severely fracturing her skull and causing other blunt force injuries, which resulted in her death. The statute defining the offense of murder reads in pertinent part as follows. A person is guilty of murder when, with intent to cause the death of another person, he causes the death of such person. For you to find the defendant guilty of this charge, the state must prove the following elements beyond a reasonable doubt. Element 1, intent to cause death. The first element is that the defendant specifically intended to cause the death of Christine Holloway. There is no particular length of time necessary for the defendant to have formed the specific intent to kill Christine Holloway. A person acts intentionally with respect to a result when his conscious objective is to cause such result. Murder is a specific intent crime. You will refer to my earlier instructions on specific intent. The intent to cause death may be inferred from circumstantial evidence. You will refer to my earlier instruction on direct and circumstantial evidence. The type and number of wounds inflicted, as well as the instrument used, may be considered as evidence of the perpetrator's intent, and from such evidence, an inference may be drawn that there was an intent to cause death. Any inference that may be drawn from the nature of the instrumentality used and the manner of its use is an inference of fact to be drawn by you upon consideration of these and other circumstances in the case in accordance with my previous instructions. Such inferences are not necessary, but they are inferences you may draw if you find they are reasonable and logical and in accordance with my instructions on circumstantial evidence. Declarations and conduct of the accused before or after the infliction of wounds may be considered if you find they tend to show the defendant's intent. This inference is not a necessary one. That is, you are not required to infer intent from the defendant's alleged conduct, but it is an inference you may draw if you find it is reasonable and logical and in accordance with my instructions on circumstantial evidence. Element 2, caused death. The second element is that the defendant, acting with the intent to cause the death of Christine Holloway, caused the death of Christine Holloway. This means that the defendant's conduct was the proximate cause of Christine Holloway's death. You must find it proved beyond a reasonable doubt that Christine Holloway died as a result of the actions of the defendant. You will refer to my earlier instruction on proximate cause. In summary, for the crime of murder, the state must prove beyond a reasonable doubt that 1, the defendant intended to cause the death of Christine Holloway, and 2, in accordance with that intent, the defendant caused the death of Christine Holloway. If you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of murder, then you shall find the defendant guilty of murder in violation of Connecticut General Statutes, Section 53A-54A at the first count, and you shall then next consider the charge of tampering with physical evidence at the second count. You will not consider the lesser included offenses below. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of murder, you shall find the defendant not guilty of the crime of murder and shall then move on to consider the lesser included offense of manslaughter in the first degree. But again, you will consider lesser included offenses if and only if you unanimously find that the defendant is not guilty of murder. Lesser included offenses to murder. In accordance with the court's previous instructions, you will consider lesser included offenses if and only if you unanimously find that the state has not proved beyond a reasonable doubt all the elements of the crime of murder. If you find the defendant guilty of murder, you shall not consider the lesser included offenses in this subsection and instead shall move on to consider the charge of tampering with physical evidence at the second count. The defendant at the first count of the amended information is specifically charged with the crime of murder. The offense of murder under our penal code is such that it may include the elements of the crimes of manslaughter in the first degree and manslaughter in the second degree. This brings into play the rule of law known as lesser included offenses. You will consider lesser included offenses in the order and under the circumstances prescribed herein. The fact that I am instructing you on lesser included offenses should not be interpreted by you that I believe the evidence proves the accused guilty of any lesser included offense. You, the jury, are the sole judges of the facts in this case. You must determine whether the defendant is guilty beyond a reasonable doubt of murder in count one or is guilty of any respective lesser included offense. If you unanimously find that the state did not prove beyond a reasonable doubt all the elements of the crime of murder and that the defendant therefore is not guilty of murder, you shall then and only then next consider the lesser offense of manslaughter in the first degree, Connecticut General Statutes, section 53A-55, subsection A, subsection 3, directly below. A, manslaughter in the first degree, Connecticut General Statutes, section 53A-55, subsection A, subsection 3. The statute defining this offense reads in pertinent part as follows. A person is guilty of manslaughter in the first degree when under circumstances evincing an extreme indifference to human life, he recklessly engages in conduct which creates a grave risk of death to another person and thereby causes the death of another person. For the defendant to be found guilty of this charge, the state must prove the following elements beyond a reasonable doubt. Element 1, conduct creating a grave risk of death. The first element is that the defendant engaged in conduct that created a grave risk of death. Element 2, recklessness. The second element is that the defendant acted recklessly. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. You will refer to my earlier instruction on recklessness. And element 3, extreme indifference to human life. The third element is that the defendant's conduct demonstrated an extreme indifference to human life. Indifference means simply not caring. It means lacking any interest in a matter one way or the other. Extreme means existing in the highest or greatest possible degree. Extreme indifference is more than ordinary indifference. It is synonymous with excessive and is the greatest departure from the ordinary. What evinces an extreme indifference to human life is a question of fact. And element 4, caused death. The fourth element is that the defendant's conduct caused the death of Christine Holloway. This means that the defendant's conduct was the proximate cause of the decedent's death. You will refer to my earlier instruction on proximate cause. You must find it proved beyond a reasonable doubt that Christine Holloway died as a result of the actions of the defendant. So in summary, the state must prove beyond a reasonable doubt that 1, the defendant engaged in conduct that created a grave risk of death. 2, the defendant acted recklessly. 3, the defendant acted under circumstances evincing an extreme indifference to human life. And 4, the defendant caused the death of Christine Holloway. If you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of manslaughter in the first degree, pursuant to Connecticut General Statutes, section 53A-55, subsection A, subsection 3, then you shall find the defendant guilty of manslaughter in the first degree in violation of Connecticut General Statutes, section 53A-55A3 at the first count. You shall not consider any additional lesser included offenses and instead shall move on to deliberate on count 2 of the amended information, skipping directly to the court's instruction below entitled Second Count, Tampering with Physical Evidence. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of manslaughter in the first degree, Connecticut General Statute, Section 53A-55A3, you shall find the defendant not guilty of manslaughter in the first degree, Connecticut General Statute, Section 53A-55A3, and you shall then and only then consider the lesser offense of manslaughter in the second degree, Connecticut General Statute, Section 53A-56A1, directly below. B, manslaughter in the second degree, Connecticut General Statute, Section 53A-56A1. The statute defining manslaughter in the second degree reads in pertinent part as follows. A person is guilty of manslaughter in the second degree when he recklessly causes the death of another person. For you to find the defendant guilty of this charge, the state must prove the following elements beyond a reasonable doubt. Element 1, caused death. The first element is that the defendant caused the death of Christine Holloway. This means that the defendant's conduct was the proximate cause of Christine Holloway's death. You will refer to my earlier instruction on proximate cause. You must find it proved beyond a reasonable doubt that Christine Holloway died as a result of the actions of the defendant. Element 2, recklessness. The second element is that the defendant's actions that resulted in the death of Christine Holloway were reckless. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards substantial and unjustifiable risk that such result will occur or that such circumstances exist. You will refer to my earlier instruction on recklessness. So in summary, the state must prove beyond a reasonable doubt that 1, the defendant caused the death of Christine Holloway, and 2, the defendant's actions that resulted in her death were reckless. If you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of manslaughter in the second degree, pursuant to Connecticut General Statute Section 53A-56A1, then you shall find the defendant guilty of manslaughter in the second degree in violation of Connecticut General Statute 53A-56A1 at the first count and deliberate on the second count. However, if you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of the crime of manslaughter in the second degree, Connecticut General Statute Section 53A-56A1, you shall find the defendant not guilty of manslaughter in the second degree at the first count and deliberate on the second count. Roman numeral 2, second count. Tampering with physical evidence in violation of Connecticut General Statute Section 53A-155. The defendant is charged in the second count of the amended information with tampering with physical evidence. The state charges in the second count that in the county of New Haven in the city of Ansonia, on or about Sunday, December 1, 2019, at approximately 2 a.m. until approximately 1:30 p.m. on Monday, December 2nd, 2019, at 6.5 Myrtle Avenue within said city, the said Jose Morales, believing that a criminal investigation conducted by a law enforcement agency is about to be instituted, the said Jose Morales did destroy and conceal and remove physical evidence of the crime of murder with the purpose to impair its availability in such criminal investigation. The statute defining this offense reads in pertinent part as follows. A person is guilty of tampering with physical evidence if, believing that a criminal investigation conducted by a law enforcement agency is about to be instituted, he destroys, conceals, or removes any record, document, or thing with purpose to impair its verity or availability in such criminal investigation. For you to find the defendant guilty of this charge, the state must prove the following elements beyond a reasonable doubt. Element 1, criminal investigation. The first element is that the defendant believed that a criminal investigation conducted by a law enforcement agency was about to be instituted. It does not matter whether the investigation was pending or not, as long as the defendant believed that it was. Element 2, tampering. The second element is that the defendant tampered with physical evidence. Physical evidence means any article, object, document, record, or other item of physical substance that is or is about to be produced or used as evidence in an official proceeding. Element 3, intent to deceive. The third element is that the defendant destroyed, concealed, or removed any physical evidence with the purpose of impairing its verity or availability in such proceeding. The defendant must have acted with the specific purpose or intent of impairing the verity or availability of the evidence. A person acts with specific intent when his conscious objective is to cause such result. You will refer to my previous instruction on specific intent. In summary, the state must prove beyond a reasonable doubt that the defendant believed that a criminal investigation conducted by a law enforcement agency was pending or about to be instituted, tampered with physical evidence, and 3, specifically intended to impair the availability of the evidence in the criminal investigation. If you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of tampering with physical evidence, then you shall find the defendant guilty of tampering with physical evidence in violation of Connecticut General Statute, Section 53A-155 at the second count. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of the crime of tampering with physical evidence, you shall then find the defendant not guilty of tampering with physical evidence at the second count. In deciding whether the defendant is guilty or not guilty, you should not concern yourselves with the punishment or potential consequence in the event of a conviction. This is a matter exclusively within the court's function under the limitations and restrictions imposed by statute. You are to find the defendant guilty or not guilty, uninfluenced by the possible punishment or consequence that may follow conviction. You should not be influenced by any sympathy for the defendant, the defendant's family, the decedent, the decedent's family, or for any other person who might in any way be affected by your decision. As I indicated earlier, your verdict must be based on the evidence introduced in court and my instructions on the law. Our system of justice depends on judges like me and jurors like you making careful, unbiased, and fair decisions. During our interactions with other people, it is not unusual for us to group or categorize people. Sometimes these categorizations involve negative or positive biases or prejudices, which may be conscious or unconscious. Such preferences or biases, whether they are conscious or unconscious, have no place in a courtroom or your deliberations, where our goal is to treat all parties equally and to arrive at a just, fair, and unbiased verdict. All people deserve fair treatment in our system of justice, regardless of their race, national origin, religion, age, disability, gender identity, sexual orientation, education, income level, or any other personal characteristic. Techniques that you can use as jurors to check whether any unconscious biases are influencing you include slowing down and examining your thought processes thoroughly to identify where you may be relying on reflexive gut reactions and to consider whether you are making assumptions that have no basis in the evidence. Ask yourself whether you would view the evidence differently if the parties, witnesses, or attorneys had different personal characteristics. In sum, your task is to render a verdict based on facts drawn only from the evidence introduced in the courtroom and from the law as stated in my instructions to you, and not based on prejudice or bias for or against any party or person involved in the trial. In conclusion, I impress upon you that you are duty-bound as jurors to determine the facts based on the evidence as it has been presented, to apply the law as I have outlined it, and then to render a verdict of guilty or not guilty as to each count. When you reach a verdict, it must be unanimous. That is, all 12 of you must agree on the verdict. As a check that your verdict is in fact unanimous, the clerk may ask each of you to individually announce your verdict in court. It is the duty of each juror to discuss and consider the opinions of the other jurors. Each of you takes into the jury room your individual experience and wisdom. Your task is to pool that experience and wisdom. You do that by giving your views and listening to the views of others. There must necessarily be discussion and give and take within the scope of your oath. That is the way in which a unanimous verdict is reached. Despite that, in the last analysis, it is your individual duty to make up your own mind and to decide this case upon the basis of your own individual judgment and conscience. Now, if you took notes during the evidence, you may use them during deliberations and you may discuss your notes with fellow jurors. Remember, notes are merely aids to your memory and should not be given precedence over your independent recollection of the evidence. If there is a conflict between your recollection and your notes or the notes of any other juror, it is your recollection of the evidence that must prevail. Your notes or the notes of any other juror are not evidence. You will recall my earlier definition of what constitutes evidence. Your verdict must be based exclusively on evidence presented at trial and the principles of law given to you in these final instructions. A juror who has not taken notes should rely on his or her recollection of the evidence and should not be influenced by the fact that other jurors have taken notes. Notes are only a tool and are not always accurate. Do not assume that a voluminous note taker has taken notes that are necessarily more accurate than your memory. You may discuss your notes with your fellow jurors during the deliberations phase. The decision to do so is yours and yours alone. After the trial is concluded, all notes will be collected by the court staff and destroyed. I remind you that you have the right to request portions of the testimony to be read back to you if you deem it essential during your deliberations. You will have all the admitted exhibits with you during your deliberations. You may only deliberate when all 12 of you are present in the jury deliberation room. Inform the judicial marshal or court officer when you have reached a verdict, but do not tell him or her your verdict. You will be asked to return to the courtroom where your foreperson will announce the verdict orally in response to questions from the courtroom clerk. The rest of the panel will be asked whether they concur with the verdict. If you have any questions, please send them out as a note signed by the foreperson marked with the time, and please be as specific as possible. You will have the full exhibits with you during your deliberations. We will also send in with you a computer on which you will be able to view or hear the CD, DVD evidence. You will also have with you in the jury room a copy of these instructions, which will be marked as a court exhibit. I remind you, however, that you should follow all the court's instructions and not single out some and ignore others. They are all equally important. Do not begin deliberations until you have selected one of your members to be the foreperson of the jury, and you have received a copy of the court's jury charge, the amended information, the device, instructions on how to access the device, and all fully admitted exhibits. So, ladies and gentlemen, at this point in time, I am going to ask all of you to return to the deliberations room. You are not able to deliberate at this point in time. I'm going to ask you to not begin your deliberations. I have to take comments on the record, and then I will bring you out here for one final moment before I send you back in to conduct your deliberations. So please, no discussing the case with one another just yet. Madam Clerk.
That was a lot.
Counsel, any comments, exceptions regarding the charge?
Your Honor, I don't have any objections to the charge. As I had mentioned, if the court wouldn't mind going to page 3 under presumption of innocence, and I think the court
I have it.
saw that.
I did.
The second paragraph, the 1, 2, 3, 4th line down ends with the word reasonable. I think it should be reasonable doubt.
That is correct. I
Thank
have
you,
that
Your Honor.
highlighted. You're right. Anything from the state?
I know that the court was, I have no exceptions to the charge itself. I did discover 2 typos on page 18, first count murder, the month of December. There's a misspelling there and the decedent's name.
Caught that. Thank you. Is there anything else?
That's it.
Okay. All right. Also on page 7. second to last paragraph. It should be whether the crimes alleged. We have more than one crime charged here, so I will just add that S. Last sentence in that paragraph. And then I will make the change to the third-party culpability charge to reflect the way that it was read back to the jury when we redirected the charge when the jury came back from break. Is there anything further?
Nothing from the defense, Your Honor.
Okay.
From the state, Your Honor.
All right, so then the court will make those changes to the document. I believe that December was read accordingly, Christine Holloway's name was read accordingly, and I did read crimes accordingly, and I did read to them reasonable doubt accordingly. So the charge was read appropriately into the record. I will make those changes because the jury will get a copy of the written charge marked as an exhibit. I think this is probably a good time just to break. It'll allow counsel to take a look at the exhibits. I will be asking you to make comments relative to the exhibits going into the jury deliberations room. So why don't we take a short recess? I will come back. I will ask you to make sure that you've taken a look at the exhibits, gone through them with the clerk, only full exhibits going to the jury, any exhibits marked as ID only, make sure that they are not going to the jury, and make sure that all full exhibits are making its way into the jury room. Counsel, do either of you wish to take a look at the device that's being provided to the jury, or you defer to the clerk?
Not from the state,
I'm
Your
fine with that, Your Honor.
Okay, and a
Your
copy
Honor,
of the
the
jury
court
instructions
exhibits,
as well.
Are the court exhibits staying here with us, or are the court exhibits?
The only court exhibit that goes to the jury is the jury charge, and a copy of the amended information will also be marked as a court exhibit.
And the instructions how to play the video. right?
And the instructions, yes,
Yep.
on how to play the DVD
Thank you.
that were prepared by IT.
There's over 200 exhibits, so that may take.
I know it may take a little while. So why don't you go ahead and get started on that? I am going to break from the bench. While you do that, make these changes, and then I'll check back in.
Thank
And
you.
then we'll bring the jury out. I'll keep the alternate juror out, and we'll send the other jurors back into to deliberate in accordance with the instructions.
Your Honor, assuming it takes 15 minutes or so, would the court have them deliberate till 4:30 or?
They would deliberate until 4:30.
What-
There are some preliminary things they need to do, such as choosing a foreperson. So I
Sure.
think it makes sense to get them going on some of the deliberations. Okay?
Thank
All
you.
right,
Your
court
Honor.
is going to take a 10-minute recess. Thank you.
Thank you.
All right, court's recess.
All right, another 10-minute recess. Thank you, Indy. That was sweet. I appreciate y'all. Y'all, I ain't even gonna lie. I was over here about to fall a damn sleep on my own live. I was like, Lord have mercy, woman. She was about to put me to sleep. It was gonna be on break, and I was gonna be nowhere to be found. Let me see. All right, now I need my history. So this one we were at. They've been peeing nonstop. Let's see if we can find where we were at for the most part. Probably about right here. Hey, Julie.
I don't know. It's something you could have cross-examined her on, but now it's probably too late.
Yeah.
If you wanted clarification on that, but the jury is going to know it's redacted, and they get the redacted exhibits instruction as part of the instructions. So either side can point that out to the jury that it's redacted. The start and the end were redacted out.
Okay.
And then what was meant by the testimony that this is the
All right. I'm going to pull up Law and Crime so that we know when she decides to come back. Lord have mercy, Jesus. Hey there, Linda. Good to see you.
full interview?
I don't know. I guess that's something that someone could have asked that witness. Maybe it was the full interview of your version of what happened.
So we have
There.
our exhibit 20, the defense's proposed exhibit 20 is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No,
Why not?
your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full interview, either side could have clarified that with that witness. I don't know what that witness meant when they said that. Anything else?
That's it.
All right, we're getting the sufficient number of the jury instructions copied. As soon as that's done and our jurors get here, we'll read those instructions. All right.
I love the way she was like, that's it. All right, let's see if anything else has happened. I think the rest is just him giving jury instructions. Looked like she asked a question or something.
Are we one? Oh, nope, we got it. Okay. Jurors have the instructions. Much like the preliminary instructions, you can either follow along with me or just listen. I need to read these into the record. Duty of jury. It is your duty as a juror to decide the case by
jury instructions again, for the love of all that is holy. Let's see if there's any new interesting highlights. We got this one from 2 days ago.
You have charged me with a crime. Is that correct?
I have not, no.
The jury in Lori Vallow Daybell's case has seen all of the evidence and they've watched her represent herself.
I got it, Your Honor.
I take a look at some of the most damning evidence against the Doomsday Cult mom and some of the wildest moments where she represented herself in the trial for the conspiracy to murder Charles Vallow.
And were we eating my green chili chicken enchiladas?
Do not remember that.
You do not remember that?
Nope.
Welcome to Crime Fix. I'm Anjanette Levy, and I just want to let you know, in case you didn't, that we are now available, both video and audio, on Spotify. So please check us out and follow us there. Now, the second week of Lori Vallow Daybell's trial in Maricopa County, Arizona, has come to an end, and it ended with Lori resting her case without calling one witness to the stand and without her testifying. Lori had repeatedly indicated, not in front of the jury, of course, that she would take the stand, but she didn't. Take a look.
Are you going to present evidence tomorrow, either through witnesses or through your own testimony?
No, Your Honor, the defense will rest.
Now, Lori is representing herself, of course. She's a trained hairdresser, not a trained lawyer. So there have been some missteps, some big ones. Some of her witnesses were precluded from testifying, and there was a big issue with her sending out subpoenas to crime victims.
So how was it an oversight?
I just signed them all, and we got them prepared, and I signed them all, and I did not check them. It's my own fault. But I apologize to the families.
So do you know the names of all the people you subpoenaed, or you just signed a stack of subpoenas?
I did sign the stack, but I thought I was aware of all that they were the ones that I had asked to subpoena.
For this trial or for the next one as well?
Just for this one. We haven't done our subpoenas yet for the next trial.
I'll try. And for the next trial, I need you to be more diligent in what you're signing and if there is a subpoena for someone who is a next of kin or a victim under the Victims' Bill of Rights, the subpoena that needs to be coordinated through county attorney's office, or is there a victim representative attorney? I haven't had one yet.
There's not a victim representative attorney, so it would come through us, Your Honor.
Okay.
Yikes. So Lori signed a stack of subpoenas, and some of them went to crime victims, and she's not supposed to be contacting them. And you heard that she apologized, but still. Now, these are the perils of representing yourself, but Lori has insisted she's got this.
Objection, relevance, speculation.
Next question.
I got it, Your Honor.
And she's been warned by Judge Boreski about the way she questions witnesses when she offers commentary.
Firefighter Kaczynski.
Okay. Kaczynski, that's one I didn't have.
Possible depending on the person.
Okay, that's fair.
So we work in tandem together. We're the investigative body and they're the scientific portion of it.
Makes sense.
Teach them to shoot till the threat went away. And that can be with one shot. It can be with.
You know, the only person she could have called is Chad because everybody else is unfortunately deceased. He does look like a toad, doesn't he, Veronica?
It's more than one shot.
Okay, that's fair.
Now, that was from the first week of the trial. It happened again during the second week.
Oh, that's right. The one I couldn't remember how to spell. I mean,
Again,
right now.
Sustained, please don't testify.
Lori Vallow has had several last names: Cox, Ryan, Vallow, and of course now Daybell. I searched her in truthfinder.com to see what might come up. Sure enough, she comes up as Lori Ryan and Lori Vallow. The name Daybell does not appear. And the murder case out of Arizona actually shows up. Truthfinder is really great because it will show you a person's past and current addresses, phone.
I went on a date with Charles.
But you did not know he was married.
I knew his divorce was not final.
His divorce was not started.
Okay.
Okay. So in your text messages, you asked Charles if he was a good kisser. Is that correct?
Maybe, sure.
Did he answer that text message?
I'm
gonna
sure.
object to
I'm sure he did.
relevance. Again, 611 harassment.
I'll sustain the objection for relevance and hearsay.
So are you trying to tell me and this jury that you went on one date with my husband and he told you all the details of our lives?
I'm telling you the truth, and that's what I know.
So you spent your whole date getting to know each other, talking about me.
Don't flatter yourself. No, we did not spend the whole time talking about you.
You knew a lot about me, right?
I knew what I've testified to.
What else did you talk about on your date?
Lots of things.
Like what, for instance?
Life, kids, the church, lots of things.
Okay. Did he tell you about anything about our other 4 children?
Yes,
So you knew that we did have 5 children as well?
I did.
Okay. Did he talk to you about my daughter, Tylee?
He did.
Did he talk about his relationship with her?
Well, I don't recall that.
Did he talk about the contention in his relationship with my daughter, Tylee?
I don't recall that.
I'm sure you don't.
I'm going to object to comments by the defendant made after questions testifying.
Let's sustain the objection.
Lori definitely seemed to let her emotions get the best of her there. And she also got upset during week 1 when her brother, Adam Cox, testified against her and didn't remember her signature dish.
And when was the last time we had any communications?
The last time I remember our communications was you and I were speaking in the kitchen when the family was over.
Okay, so you think that was that time in 2018?
I think so.
Okay. And were we eating my green chili chicken enchiladas?
Do not remember that.
You do not remember that?
Nope.
Is that what I made every time we had a family get together, which was like 10 times a year?
I don't remember that.
Okay.
bing, bop, boom, 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 bop, bam.
And when was the last time that we had a phone call or text message?
I have no idea.
You don't often see something like that in a trial. Then there was Lori's cross-examination of Kay Woodcock, Charles's sister.
Were you aware at all of the relationship between Charles and Tylee?
It was, let's say, it was a bit contemptuous. It seemed like there was always a lot of drama going on, and so that's all I knew. He didn't say too much about it, and I didn't pry.
But you knew that there was some kind of contention going on with those two for
I can't
a
hear
while.
you.
I'm sorry. You did know that there was some kind of contention going on with those two for a while.
Yes.
Okay. And you weren't really aware of the events that happened that morning, were you?
The morning of his murder?
Of July 11th?
No, I wasn't.
Okay.
Because you didn't tell me.
Ms. Woodcock, did you see or hear or personally witness me conspire with Alex Cox to kill my husband, Charles Vallow?
No, but I saw a ton of evidence that did.
Thank you. No further questions.
So that was how the first week of the trial ended. And the thing about this case is that, yes, it's a murder case, but it's also a case about a conspiracy, a plan. So the question to Kay Woodcock about whether she heard or saw Lori conspire with Alex to kill Charles seemed a bit odd. The second week of the trial focused more on the investigation and Charles Vallow's wounds.
Doctor, given the trajectory that you observed, that from the gunshot wound to Charles's abdomen that exited his left shoulder, and the fact that the gunshot wound was short, would that be consistent with the shooter standing somewhere near Mr. Vallow's feet and firing at Charles Vallow as he was laying on the floor?
Yes, that's certainly possible.
Dr. Derek Bumgarner testified that Charles Vallow was already on the ground when he was shot. Remember, this is a self-defense case. And listen to this.
What is a short exit wound?
A short exit wound occurs when the body is pressed up against a firm surface while the bullet is exiting the skin.
Does that cause sort of this different tearing that we see going on here in that exit wound?
It does.
If a person was, for instance, laying on the floor when they were shot, would you expect to see a short exit wound in that situation?
I would.
When you're talking about something pressed up against the skin, have you ever seen a short wound from someone wearing a t-shirt?
I have not.
Have you seen other short wounds in your experience?
I have, yes.
Approximately how many have you seen in your years of working?
I mean, they're relatively rare, so maybe less than 50.
Lori had suggested through questioning another witness earlier in the trial that Charles Vallow's bamboo t-shirt could have caused the short wound. On cross-examination, Lori had questioned Dr. Bumgarner about other injuries Charles had to bolster her self-defense claim.
As far as the abrasions on Charles' knees, could those have been, you said that they were consistent with having been close to the time of death, is that correct?
They had that general appearance, yes.
And so those abrasions could have been caused by a scuffle before he was shot, is that correct?
Yes.
And not necessarily falling forward onto his knees.
Correct.
And then the abrasions on his hands as well,
What about them?
that they could have been caused from a scuffle beforehand.
Yes.
Okay.
The jury also heard from Detective Cassandra Yanklin, who interviewed Lori the day of the shooting. She testified about her interactions with Lori.
Detective, did we answer all the questions asked to us by the police that day?
By me, yes, I believe so.
And we were dropped off at home by the police, is that correct?
Correct. I drove you back to the house.
And we were given no further instructions, is that correct?
Just that we would be in touch with you at the conclusion of the search warrant.
Is it also correct that we voluntarily handed over Charles' phone to you when you asked for it?
Yes.
Did we delay in that or just do it immediately?
No, you gave it to me when I asked.
I think so, Mercedes.
Was there any time, Detective, on July 11th, 2019, that we did not comply or cooperate fully with the police in their investigation?
In my interaction with you, you were cooperative.
Thank you. That's all I have, Your Honor.
Again, Lori was warned during her questioning of the detective.
In the course of your investigation, did you ever learn that Charles had stolen my phone, so I had to replace it?
Object to testifying and move to strike.
Sustained.
Your Honor, it's all part of the investigation.
You're gonna object again.
Sustained, it's testimony. The form of the question was testimony.
Were you aware that after he gave it back to me that I kept both phones?
I'm gonna again object.
Sustained.
The jury also heard Lori Vallow Daybell calling Charles Vallow's life insurance company 4 days after he died to claim that $1 million life insurance policy.
And what was the date of Mr. Vallow's passing? July 11th. And what was the cause of his passing? Well, he was shot. Okay, so I don't know how I want to put that. Okay, all right. And I hate to ask, but is it? Yeah, you can just say yes or no. Was it a homicide? No, it was an accident. An accident. Okay. Mm-hmm. Okay. And what state did he pass away in? Arizona. Okay. All right, just bear with me for one moment. I just need to pull up a few other things. Okay. Okay. Are you aware of who the primary beneficiary of the policy is? It's me.
But it wasn't Lori. Charles had changed the beneficiary to Kay Woodcock months earlier. Lori would later discuss this in a text message with Chad Daybell.
And so we learned that Lori received a email indicating she was not the beneficiary, and later she had a phone conversation.
Correct.
Does this one appear to be sort of the earlier one because it references, I just got the letter from the insurance company saying that I'm not the beneficiary. It's a spear through my heart. Who do you think he changed it to? Brandon or probably Kay? He left nothing for JJ.
Correct.
Did that conversation go on? Wow, that's terrible. There's no way to find out.
It did.
And did Lori then tell Chad, I might be able to see when I get his computer on Sunday, I could check the email sent to the insurance company. It will show change of beneficiary. He must have done it recently.
Correct.
So we had seen, in fact, photos what appeared to be from a computer that were sent to Chad Daybell, correct?
Correct.
Showing that beneficiary change.
Yes.
So does that seem to match with, again, what Lori's telling Chad here about finding out who got that money?
It does.
The jury also heard about Lori marrying Chad later that year in Hawaii. The jury also heard about a text between Lori and her brother, Alex Cox, before Charles was shot.
On July 9th at 9:50 p.m., does Lori Vallow send her brother, Alex Cox, a message, getting sleepy, so I'm going to need you to stay close to me the next couple days. Mel, too. She can't go to Utah. They are planking some kind of intervention, but want Mel out of the way, so I'm left alone.
I need to come get the stuff at your house tomorrow and store it or secure it. Lots to do. Thank you for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you. When you saw that message, did you ever check Alex Cox's cell phone records to determine whether or not there was a phone call after that?
I did.
Did you see that Alex Cox and Lori Vallow talked on July 9th at 21:56 hours? What time would that be?
9:56.
So 6 minutes after this, or 56 minutes.
Correct.
So 6 minutes after this text message, Lori and her brother have almost an hour-long conversation.
Yes.
Now, in this message, when you were going through these records, did you recognize or learn who Nephi was?
So in going through this particular message, I knew that Nephi was a figure in the Book of Mormon related to the Church of Jesus Christ of Latter-day Saints, but I didn't understand the significance.
Adam Cox, Lori's other brother, testified in week 1 about the significance.
Can you tell us about the story of Nephi?
Nephi?
Mm-hmm.
Well, Nephi was a prophet in the Book of Mormon. It's the first chapter. He was a prophet, very humble and faithful servant of the Lord. Ironically enough, his brothers tried to kill him at one point. But he actually ended up going to Jerusalem to get these plates back, and he was run off, came back, and then went back again because the Lord asked him to. And when he did, the King Laban, who was actually a wicked king, was laying on the ground drunk in front of him, and Nephi was told to kill Laban.
Who was he told by?
The spirit, or God.
So God was using a Holy Spirit to tell him to kill Laban, and
Yes.
did he?
Yes, he did.
Was that something he anguished over?
Yes.
But ultimately, it was a justified killing.
Yes.
So the jury has now heard that the prosecution believes Lori and Alex believed that killing Charles was justified, but Lori had tried to distance herself from Adam when he testified.
I mean, yeah, when I heard that, I was like, so you're saying that you're justified in killing this man?
Mr. Cox, how long has it been since we've seen each other in person?
Don't know.
When was the last time you saw me?
I don't recall.
So, has it been a year, 2 years, 3 years, 5 years, 6 years, 7 years, 8 years?
Something.
Okay. So, you have no idea.
Nope.
You have no idea when the last time you saw me in person.
I don't know the year or how many years it's been.
Okay. So, did you see me at Colby's wedding in January 2018?
No, I was not there.
You didn't come to Colby's wedding.
No, I did not.
So did you see me sometime that year at my house
Possibly.
where Colby got married? That house,
I did see you at that house. Yes.
at least one time.
Yes.
So possibly in 2018.
Yes.
Now back to Charles Vallow's phone. You've heard Lori had it that day. The jury also heard testimony about where it was and what was going on with it after Charles was shot.
When was that read?
12:13 as well.
Is Charles Vallow alive at 12:13?
He is not.
So someone else is reading those.
Yes.
And this is coming from the extraction of Charles Vallow's phone.
Correct.
Do you know who was in possession of Charles Vallow's phone at 12:13 p.m. on July 11th of 2019?
Lori?
I believe so, Linda.
How do you know that?
She told us, and she turned the phone back over to us later that afternoon.
Did you ever find any other evidence that Lori Vallow and Alex Cox went through Charles Vallow's phone on July 11th of 2019?
Yes.
On cross-examination, Lori questioned Detective Nathan Duncan about things that were not done in the case, like testing the baseball bat for DNA. She continued to grill Detective Duncan about the investigation.
Now, we learned that the bat was swabbed for DNA and sent to the lab. Is that correct?
Yes.
All right, now let's
And was that ever tested?
No, it was not.
And why not?
When making this decision, you have to look at the probative value of that and what that would show or what a test would prove. DNA and fingerprints are not time specific. That bat was owned by Tylee, to our knowledge. It was in a household where you lived. It was in a household where Alex was. And at one point, based on the fact of when we understood the bat to have been purchased, Charles was living in the house as well. So that bat was accessible to all those people. So if at one point during that time, that person touched that bat, all that it would be saying is that somebody touched that bat at some point, not during this incident.
Right.
Lori continued to question Duncan about the bat.
But would that be able to be told from DNA?
There was nothing that was visible that could see, like if blood dries or anything like that. There was nothing that would indicate that here's a spot we need to test for that particular, for blood.
Right. But would DNA tell if there was blood? Could they find out if there was blood on the bat from the DNA test?
Once again, blood is, you would see if it dries and crusts, then you would see that particular blood. DNA comes.
Okay, they're finally back 30 freaking minutes later. 10-minute break turns into 30 minutes. So let's go do this. What is it? Goodness gracious, this woman. I'll be glad when this trial's over. This judge is all.
Anything else that you feel needs to go to the jury?
No, Your Honor.
All right. I did discuss an exhibit list. I err on the side of caution, so I don't usually provide it. Does anyone have an objection to that?
We're asking that it not be provided.
State is fine with that, Your Honor.
All right, so I will let you know that I am going to address the alternate juror. I am going to ask the alternate juror to remain present in the jury assembly room and to return day after day until we have a verdict in this particular case. Okay?
Thank
All
you,
right,
Your Honor.
thank you. All right, Madam Clerk, if we could please have the jury. Counsel, please stipulate to the return of our jurors.
Stipulate to the presence of the jury, Your Honor.
Thank you. All right, ladies and gentlemen of the jury, it is at this point that I'm going to excuse the regular jurors to the deliberations room. I am going to ask the one alternate juror to please remain in the courtroom. I will provide additional instructions. You are in a position where you can begin your deliberations in accordance with my instructions, which means that once you get back into the deliberations room, you are not to start deliberating until you have selected a foreperson and until you have received all the items that I indicated that you needed to have with you, which include the full exhibits, the jury charge, which has been marked as a court exhibit, the amended information, which has also been marked as a court exhibit, the computer device and attachments, instructions on how to access the computer device, which has also been marked as a court exhibit. So once you have all of those things and you've selected a foreperson, you may begin your deliberations. I do intend to wrap up court today at 4:30, but I would ask that you deliberate in the meantime for however much time that there is left between now and 4:30. So if all regular jurors would please stand, with the alternate juror to please remain seated. Thank you. And if you wouldn't mind going to the deliberations room. May I just get your initials? Yes. Okay, I just want to make sure I have the right juror behind. Thank you. So it is my duty to address the alternate at this point in time on the record. First of all, I want to thank you for your attention throughout the trial. I know it must be somewhat frustrating to sit here and hear the evidence and not participate in the deliberations, but you do perform a very important function in our jury system, and we really appreciate you being here with us. Now, while it is unusual, alternate jurors are sometimes called to take the place of a regular juror, even during the deliberations phase of a trial. For that reason, I am going to ask that you report back to the jury assembly room after I excuse you here in a moment. And I'm also going to ask that you do report back to the courthouse day after day to the jury assembly room until such time as a verdict has been reached in this case. I want to remind you that the same instructions do apply to you, as I've repeated them throughout the trial. So please do not read, listen, or watch anything about this case. Do not speak to anyone about the case or let anyone speak to you about this case, including any of the regular jurors in this particular matter. Also, do not make any private investigations or do any research. When there is a verdict, we will bring you into the courtroom if you so choose, so that you can hear the verdict as it is read aloud here in the courtroom. Okay? So you understand?
So I come here tomorrow?
You will come tomorrow at 10 a.m.
Okay.
And you'll just report to the jury assembly room, and Madam Clerk there will give you further instructions. Okay?
Can I go there now?
If you don't mind, when you're excused, the marshal will direct you back to the jury assembly room until 4:30, at which time I plan on adjourning for the day. Okay? Okay, thank you. Thank you for your continued patience with the process. All right, so Madam Clerk, everything that the attorneys have gone through and that the court has looked at is on that wooden table over there. If you'd please bring those items into the jury so that they can begin their deliberations. Counsel, is there anything further? All right, court's going to stand in recess.
All right, so
I will notify everyone if and when there is a verdict.
Oh, they muted it. So now we're on verdict watch. You feel bad for the alternate jurors? I know, he's so cute. It is ridiculous. I will record him eating crackers at some point. Okay, well, I'm going to go for the day. I don't think they'll be back today with a verdict, but I will be on verdict watch and watching for them to come back with a verdict. From what I understand, Stephen Stearns has a hearing at 11:15 tomorrow on the motion to continue the hearing for the 23rd, which I do believe is Wednesday. Yeah. So tomorrow morning at 11:15 is to hear the motion for continuance, and then depending on that, we will also have court Wednesday. So if it's broadcast, I'll be live at between 11 or 11:15 tomorrow. And then if they have court on Wednesday, that's supposed to be at 2 p.m. So I'm sorry, Abellis. I'm so sorry, love. I appreciate y'all hanging out with me though. And yeah, as soon as we get a verdict in, we'll go live with that. So I love y'all. and I'll see y'all in the morning. Stay safe, everybody. If nobody's told you, you are important, you are special, you are loved. I love you. Basil loves you, and I'll see y'all tomorrow. Bye.
Listen up, I gotta tell you, there is something you should know. I have never really liked you at all. I cannot hide it anymore. I've been thinking about the future, trying to forget about the past. So many ways that I could change for the better. Don't even know where to begin. If I allow myself to dream, will it be as good as it seems?